Welcome to our daily YouTube session. Today we will discuss the issue of caste discrimination in general and the ruling of Orissa High Court in the context of SC/ST Act in particular. So first of all, we will start with the issue of caste discrimination. हम सभी लोगों को पता है that the Constitution of India हमें fundamental rights provide करे गए हैं and foremost और द मोस्ट इम्पॉर्टेंट अमंग देम आर आर्टिकल 14 जो हमें क्या प्रोवाइड करता है, दैट इज राइट टू इक्वालिटी, एंड आर्टिकल 21 दैट इज कॉल्ड एज राइट टू लाइफ विद डिग्निटी. Okay, which protects basically the basic human rights of each and every citizen of our country. अब हम ये भी बोल सकते हैं कि यही फंडामेंटल राइट्स हैं जो क्या रिस्ट्रिक्ट करवाते हैं आपकी कंट्री में डिस्क्रिमिनेशन, और हर एक सिटीजन को प्रोवाइड करते हैं इक्वालिटी ऑफ अपॉर्चुनिटी एज वेल एज इक्वालिटी ऑफ आउटकम. ये हमारे कॉन्स्टिट्यूशन के प्रियम्बल में भी लिखा गया है दैट वी द कॉन्स्टिट्यूशन वांट्स टू सिक्योर दैट इज जस्टिस है, लिबर्टी है, इक्वालिटी है, फ्रीडम है. लेकिन हमने ये भी देखा है दैट स्पेसिफिकली द वनरेबल सेक्शन ऑफ आवर सोसाइटी, इन द कंटेक्स्ट वनरेबल सेक्शन मतलब जो डिप्रेस्ड है, जिनके खिलाफ डिस्क्रिमिनेशन हो रहा है, जो अब इनक्वालिटी के लिए ज़्यादा वनरेबल है, जैसे कि आपके वुमेन हो गई, फिर अभी हम जिस कंटेक्स्ट में बात कर रहे हैं दलित्स हैं, ट्राइबल्स, देन चाइल्ड, ओके एट्सेट्रा, दे आर स्टिल फेसिंग द डिस्क्रिमिनेशन. उनका आर्टिकल 14 है, आर्टिकल 21 है या आर्टिकल 19 है, इट इज़ स्टिल बीइंग वायलेटेड. और हम बात अगर कास्ट डिस्क्रिमिनेशन के कंटेक्स्ट में कर रहे हैं तो हम यहाँ पे बोल सकते हैं कि स्पेसिफिकली जो उनका आर्टिकल वायलेट हो रहा है बेसिकली अलॉन्ग विद आर्टिकल 19, आर्टिकल 14, आर्टिकल 21 विच आर ऑब्वियसली द कॉर्नरस्टोन ऑफ आवर डेमोक्रेसी, दैट इज बीइंग आर्टिकल 17 जो एक्सप्लिसिटली अनटचेबिलिटी है, जो फॉर्म ऑफ डिस्क्रिमिनेशन एग्जिस्ट करता है लोअर कास्ट इंडिविजुअल्स के साथ, उसको बैन करता है. लेकिन डिस्क्रिमिनेशन आज भी हम देखते हैं दलित इंडिविजुअल्स के साथ. किस कॉन्टेक्स्ट में? देखो, डिस्क्रिमिनेशन आपको मेंस में पूछा भी जा सकता है दैट व्हाट आर द वेरियस टाइप्स ऑफ डिस्क्रिमिनेशन दैट आर स्टिल प्रेवेलेंट अगेंस्ट द लोअर कास्ट इंडिविजुअल्स. तो यहाँ पे डिस्क्रिमिनेशन हमें किस फॉर्म में देखने को मिलता है? हो सकता है अनटचेबिलिटी, जैसे हमने पहले बात करी, कास्ट वायलेंस हो सकता है, रेजिडेंशियल सेग्रीगेशन है, और जो हमारी रूलिंग आई है उड़ीसा हाई कोर्ट की स्पेसिफिकली कास्ट नेम स्लर्स की, ठीक है, उस कंटेक्स्ट में भी डिस्क्रिमिनेशन किया जाता है. दो हम ये बोल सकते हैं कि डिस्पाइट द ऑब्जेक्टिव्स और डिस्पाइट द विजन दैट वाज प्रोवाइडेड बाय आवर कॉन्स्टिट्यूशनल मेकर्स एज वेल एज द कॉन्स्टिट्यूशन अंडर आर्टिकल 14, अंडर आर्टिकल 21, अंडर आर्टिकल 19, फर्दर इक्वालिटी ऑफ अपॉर्चुनिटी एज वेल एज आउटकम. तो हमने क्या देखा है, बेसिकली ये राइट्स हमें फुलफिल नहीं हो रहे. कुछ सेक्शन हमारी सोसाइटी के ऐसे हैं जो आज भी डिस्क्रिमिनेशन को फेस करते हैं, जैसे कि मैंने आपको बताया यहाँ पे दलित्स हैं, वुमेन है, चाइल्ड है, ट्राइबल्स है, और भी बहुत सारे सेक्शंस हैं. और दलित्स के कंटेक्स्ट में बेसिकली आपके पास डिस्क्रिमिनेशन किस फॉर्म में मिलता है? इट इज सीन इन द फॉर्म ऑफ अनटचेबिलिटी, कास्ट वायलेंस, रेजिडेंशियल सेग्रीगेशन एंड कास्ट नेम स्लर्स. और इसी कंटेक्स्ट में विद रिस्पेक्ट टू यूजिंग ऑफ the name of caste to discriminate lower caste individuals, the ruling has been given by the Orissa High Court in the context of SC/ST Act. So I hope I am clear with this. तो आगे चलेंगे. First of all, we will try to see basically what is the SC/ST Act, what are its provision, what does it try to say, what kind of atrocities basically it defines, or what are its basic objectives. So first of all, it states that the act lists various offences relating to various patterns or basically behaviors inflicting criminal offences. Such type of offences, for example, I have already stated you, such as untouchability, public entry or private entry ban, residential segregation, employment, hiring, various forms of offences are there. It tries to basically criminalize those offences which discriminate against the scheduled caste as well as the scheduled caste and breaks their self-respect and esteem. So you must all know that our Article 21 states that we have right to life with dignity. So whenever the self-respect and esteem of any individual or any lower caste group is violated, that is being under Article 21, that is right to life with dignity. And when such discrimination happens, basically what is done is it leads to denial of economic rights, it leads to violation of democratic rights such as right to vote, right to freedom, social rights, basically for example right to participate in social functions, right to participate in society, then discrimination, exploitation also, and abuse of the legal process. For example, sometimes crime has happened against a Dalit individual and FIR is also not registered basically against those individuals who have committed some crimes. So what does this provision try to highlight is that the act highlights various offences, okay, and tries to criminalize them, and those offences which basically violate Article 21 of our constitution, that is self-respect and esteem, and further which leads to economic, social, or basically exploitation and abuse of the legal process. What does the second provision state? Second provision states that basically under section 18 of the act, a provision for anticipatory bail, okay, is not available to the offenders. It means basically if somebody has registered an FIR, you cannot go prehand to the court and claim a bail, so that you won't have to go to jail for that purpose. So anticipatory bail mechanism is also not available. Further, a public servant, many a times, as I have already listed the example, many a times we see that a crime or some atrocity is committed against the lower caste individuals, and when they go to the police stations or any public administration office, so what they face is basically the individuals who are sitting in those public offices, they won't hear to their complaints, okay. Further, they will harass the individuals because of their low caste. So it tries to bring proactive actions on the part of the public servants. Any public servant who deliberately neglects his or her duties is liable to punishment with imprisonment for up to 6 months. If the government finds out that that public servant has failed to deliver justice, he has basically deliberately acted against the people belonging to the lower caste, for example has failed to register the FIR, has failed to register a complaint, that individual can be held imprisoned up to 6 months. Moving further, okay, then what we see was that basically there was an amendment in this act, that is SC/ST Prevention of Atrocities Amendment Act 2015. So what does it states? That it, first of all, it recognized more instances of atrocities as crimes. So what we get from this is it increased the scope of the act, okay. Further, provided through wider coverage, tried to protect the self-respect and dignity of lower caste individuals. So it recognized more instances of act, it brought a wider coverage to the act, widened the scope of the act. Second thing, it provided for establishment of exclusive special courts. Again, very important point, this can be again asked with respect to your prelim exams. So it provided for special courts and special prosecutors who are to be tried under offences under the, that is, Prevention of Atrocities Act. Then, so why these basically special courts are provided under this act? Obviously, what we will state is that is fast justice delivery, and it will bring a time bound, okay, redressal of the case. So that is in. Then act defined the term willful negligence. We earlier in our last slide also we saw that in the respect of public servants the term was given, that was willful negligence. So here 215th Amendment Act, what it did was it defined the term willful negligence in the context of public servants at all the levels, whether it is clerical, whether it is at the basically B grade services, whether they are from the A grade services, starting from the registration of the complaint to the dereliction of the duty under this act. So willful negligence was also defined so that any public servant could not escape from the loopholes of the law. So further, if accused was acquainted with the victim of his family, the court will presume that accused was aware of the caste or tribal identity of the victim unless proven otherwise. For example, some individual may go to the court and state that basically I did not know that his caste identity, if I say the name or if I pronounce the name of the caste or the tribal identity, that is considered as derogatory, it is used as a form of discrimination, so he may try to escape that process. But the amendment specifically stated that if individual is acquainted with the people belonging to the lower caste or from the tribal individuality, he or she basically knew that the pronouncing the name of the caste or using that as a caste slur basically was a derogatory and a criminal offense, so individual will not be able to escape the law. So further, Orissa High Court gave a ruling here in the context of the caste slur. The court stated that, so what the court said, the court noted that it was unjustified to assume that the accused person has used the caste slur with the intention to humiliate the victim. So it kind of put a basically filter to this provision. It stated that just using the name or pronouncing the name of the caste, just give me a second. It stated that just pronouncing the name of the caste cannot be considered as an offense unless and until the intention of the individual or intention of the perpetrator was to humiliate the victim. So what, only in those instances where the intention was to humiliate the victim, only in those cases the individual will be held liable. Unless and until you cannot prove the intention to humiliate, the individual will not be prosecuted under this act. Next, it stated that under such circumstances the High Court ruled that if someone is abused, be very clear here, if someone is abused with the name of his caste or the caste is uttered suddenly in the course of events and during the incident, by itself would not be sufficient to hold it that any offense under the SC and ST Act. So the court basically, in layman terms or in simple terms, what you need to learn is the court stated that just using or pronouncing the name of the caste does not mean that you are basically humiliating or discriminating against the individual, unless and until the intention is to insult or humiliate the victim for the reason that he or she belongs to the scheduled caste or scheduled tribe. An individual belonging to the lower caste cannot basically hold another individual liable under the offense that you have used the name of my caste, and so it is an offense. I am basically offended by it, and you will have to I will file a complaint or FIR, whatever it is. But the court stated that the intention, only in those instances individual will be held liable where the intention is to insult or humiliate the victim, that individual belong to lower caste, not just using the name. So further, we have also a Supreme Court judgment with respect to this case, and that is Kashinath Mahajan judgment with respect to this. It introduced some key safeguards here. First of all, it stated that the bar on anticipatory bail, what we learned, just try to recall that in one of our previous slides, that anticipatory bail was not available. So it stated that the bar on anticipatory bail need not prevent courts from granting advance bail if there is no merit in a complaint. So further, what can be said is that Supreme Court stated that the exception to basically anticipatory bail is there. The provision that denies anticipatory bail in case of basically offense under this act is not absolute. If the court finds that basically the complaint is, there is no merit in the complaint, okay, then the anticipatory or advance bail can be granted to the individual. Further, before arresting a person, a preliminary inquiry has to be conducted, okay, in all the cases before the registration of the FIR. Then last thing is what the court said, the person can be arrested by an investigating officer only if the appointing authority, in case of public servant or the SP, approves such arrest. So 3 bars basically that was provided by the Supreme Court to stop the abuse of the case. abuse of the act. What were that 3 bars? First of all, that provision of anticipatory bail is not absolute. There is exception if there is no merit in the case, then the anticipatory bail can be granted. Then there is a case of preliminary inquiry, that before the registration of FIR, this inquiry has to be conducted in all the cases that are basically registered under this act. Then a person, if you are to arrest an individual, if there is an officer who wants to arrest the basically perpetrator, then he will have to approve such arrest from the superintendent of the police. So this was what was provided by the Supreme Court. Moving forward, we also need to know that how effective has been this SC80 Act, which provides, again, aims to ensure self-respect, dignity, and aims to uphold some fundamental rights of the lower caste individual. But we can see that this act has not been very much effective. As per basically first instance, we can see that despite the enactment of this act, as per NCRB report, that is National Crime Record Bureau report 2019, crimes against the member of scheduled castes and scheduled tribes have increased respectively by 7.3% and 26.5% in 2019. Then if we take a state-wise scenario also, Uttar Pradesh has the most number of cases of crime against SC/STs basically, okay, followed by that is Rajasthan and Bihar and Madhya Pradesh. So where earlier there is assumption that these are the states where some sort of caste discrimination is very much prevalent, those states are still at the basically forefront. Then there is some issues with respect to conviction rate also, according to status report, okay, over the decade prior to 2018, the conviction under Prevention of Atrocities Act is just in case of scheduled caste 25%, and in case of scheduled tribes that is 22.8%. So from here or these instances we can state that this act has not been very effective in upholding self-respect, dignity and fundamental rights of the individual. And how can we say that? Obviously, first we have a data from increase in the crime rates, then there are states where such crime is basically registered at a higher rate, then conviction rate is also not very encouraging. So this is where a mains question can be asked to you with respect to this topic. Next, moving forward, but we also need to write a way forward if a question comes along. So what you can say that, see, law cannot only realize the vision of the constitutional makers because it only works on fear and deterrence, but this is not enough to make a country where everybody has equal rights, opportunities and access to justice. It is only one of the steps. What we need along with the law is we need educational and economic advancement of the backward communities like SCs, STs and in India, and educational reforms all over the country so that the root cause of the discrimination can be dealt with. So what you will say that law is there, that is okay. What we can do is we can strengthen the law. Okay, further we can ensure effective, what we say is implementation of the law. But overall what we need to do is, along with this, we need educational awareness as well as economic advancement of the people belonging to the lower caste as well as the scheduled tribes. So along with this, we have covered a mains question also, but we will also cover a, what we say, prelims question also. So the first statement that you see here is, that is Protection of Civil Rights Act 1955, okay, has been enacted for meting out punishment for preaching and practicing untouchability. Okay, second thing is that Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act has been enacted to prevent atrocities against scheduled caste and scheduled tribes, which one of them is true. As you know, we have already discussed the Prevention of Atrocities Act, so obviously it was in the context of scheduled caste and scheduled tribes, and name also signifies that, so this statement is true. Then you have a statement above, that is Protection of Civil Rights Act. Okay, you need to have such basic general awareness that under Article 17, that is removal of untouchability, this was one of the first acts that was basically enacted to what we say curb the discrimination against the lower caste. So in this context, the statements both 1 and 2 are correct. So that is all that is there from my side. We will meet in our next class. So thank you very much.